Good evening. We are live. We are live. What are the news? We want to talk about immigration as you know it. Hello, let me know. Where are you? What you doing? How you feeling? Let me know in the comment. I'm having my live session on my phone. Let me see if there's okay. Yes. So I'm having my live session on my phone. We want to talk about immigration. Hold on. If you're new to my channel, please go ahead and subscribe. Okay. So, good evening. Good evening. How are you? If you have a question, put it in the comment. Yeah. Oh, the lightning. Okay. Is it good? The lightning. The lightning is something here. Okay. Anyway, we are here live. We want to talk about immigration, okay? I'm here to answer your questions because we have a lot of things going on as far as immigration is concerned. Where are you located? Washington, D.C., Virginia, Maryland, Washington, D.C. How are you, El Mazouk Adishi? How are you? How you feeling this lovely Saturday? We want to talk about immigration, okay? Because a lot is going on, okay? Georgia, Texas, Florida, Tennessee, just a lot is going on. You're doing well. Thanks for joining. By the way, please go ahead and like and share because we really want to talk about immigration and what exactly is going on. Number one news going on, 200,000 cases have been dismissed from immigration court. 200,000 cases dismissed from immigration court. Why? Because DHS did not file a notice to, they did not notify the people, right? If you have been referred to immigration court, you have to be notified. They have to serve you. DHS failed to serve people. So those cases have been dismissed. But the bad news is if immigration court was the only place you were supposed to get your asylum granted or argue for your asylum, then now you pretty much out of luck. So you have to either start over with USCIS depending on whether or not USCIS is going to take your case, because remember now it's going to go to the vetting center. This is really bad news for a lot of people because if asylum is your only type of relief, but if you have adjustment of status and your case has been dismissed, maybe that's good luck, right? Now you can already go to USCIS. So that's what's going on. That's number one type of news. Who's saying, does USCIS respect the processing time they put on your account? Charis Kadosh. No, USCIS does not respect the processing time they put on your account. Really, the only time they respect the processing time on your account is when somebody applies for work permit under asylum, first time applicant, at least what I've seen so far, they're getting those work permits within 30 days, okay, because that's the law. They have to do it because somebody sent them to court, right? So that's why now they have to respect that. So other than that, they don't respect anything. Yeah, they don't respect anything. So anybody else has a question, just put it in the comments. I'm here to answer your questions. Yes, I was talking about those 200,000 cases, okay, dismissed. Those cases have been dismissed from immigration court because the Department of Homeland Security failed to do their job. They failed to refer those people to courts. They failed to notify the respondents. They failed to notify them that they have immigration dates in courts and something like that. So the judge basically dismiss those cases. Two ways or two scenarios. If you have to adjust status with USCIS, then it's a good news. But if you don't have to adjust status with USCIS, you don't have any type of relief, asylum was the only thing you were supposed to defend in court, or cancellation of removal. Now, you're gonna have to find a way to fight it, because that's like bad news. How would you know if your case has been dismissed? Well, if you look at on USCIS, not USCIS, sorry, on the court, basically on your court website, you put your alien number. It's supposed to show you if you're in court or you're not in court. But those people are the people who were supposed to receive a notice to appear, and they never received it, basically. The case was never referred to court. So, you know, it's like basically somebody come from the border, crossing the border, got arrested, detained, and then they tell them, after passing the credible fear, they tell them that we're gonna send your case to court, and then they just waiting and waiting. There's no cases that have been sent to court. So, what else? Can someone get a proof for VAWA if they've been guilty of what? Elma should I don't know what 240.20 New York's penal code, because I'm not in New York. I don't know what, you have to tell me what type of felony it is, because I can't go with the number because I don't know it in my head, like what is 240.20 in the penal code. I don't know it in my head. I have to look it up, right? But you can just put what type of felony it is right there. For how long notice to appear? Is there exact timeline under which notice to appear must be received before court date? No, I don't think there's an exact time. But if somebody, Charles, if let's say somebody gets here, right, and they tell them that they're gonna refer their case to court because that's where they're gonna get their asylum granted or defend their asylum. If you don't receive it, it's really bad for you because that's the only solution you had. So they're supposed to do it right after you get out of detention, basically. As far as timeline, I don't think there's like you have to give it within like 30 days. That's not how it works with those notice to appear. But really, when they release you, when they release somebody from detention center, they send them to court, they should be notified like anytime, basically. But if it's taking too long, they haven't notified you, then the judge just dismissed those cases because USCIS failed to enter those notice to appear. Now you pretty much like on your own. The only thing that's gonna be good for the person is if they have to adjust status with, let's say the person gets married and they have to adjust status with USCIS, then that's good, right? The case is dismissed while USCIS has jurisdiction, now they can go. But if asylum was the only thing, or cancellation of removal, for example, you have to defend it in court, then the person is out of luck. So then they have to try to, you know, fight the DHS or something around those lines, but you know, that's becoming, again, a long story. Let's see, who else has a question? Yeah, we were talking about those 200 cases being dismissed. Then we have to talk about what exactly is going on in Texas, okay? In Texas, what's going on is that, remember they have this SB4, that law in Texas that says that if somebody gets to their border illegally, they have to be arrested by the police, put in jail, first-time offender for 6 months, second-time offender up to 20 years. Then they give the judge the power to deport that person to Mexico, even if the person is not from Mexico. So what happened was this law was supposed to take to be effective or to take effect on March 5th. But then the Biden administration started fighting. Finally, it was referred to the U.S. Supreme Court. Then the U.S. Supreme Court decided that, well, this law has to take effect. But the good news is they remanded the case back to lower court for some type of determination, but then the lower court has suspended that law because they have to hear arguments, which is good. At least for now, they cannot arrest anybody based on that law because it has been suspended, at least for now, as of today. What's going on in Florida? In Florida, it's going bad because right now they're recategorizing, like they're changing category of felonies, pretty much making it really hard for an immigrant to get any type of benefit based on those type of felonies. I talk about it, what is going on in Tennessee, same thing as Georgia. They are trying to pass the bill. The bill has already passed the House, but they're trying to pass it in the Senate as well to make sure that the local authorities are reporting undocumented immigrants, arrest them, put them in deportation proceedings, and basically deport them. Yeah, we are seeing those things from each state. Like every state is trying to take some type of law against immigrants. That's basically what's going on. I don't know how it's gonna end up, basically. So what else? Oh, can someone be approved for VAWA if they have been charged of disorderly conduct? It goes with good moral, right? Good moral and character, crime involving moral turpitude. I think they might be approved. Not for sure thing, but they can, again, waive that. And because VAWA is a self-petitioner, they can waive it. That hopefully gets waived. Yeah, I think that's not a ban for the VAWA to be approved, basically. They can try to waive it, so to speak, disorderly conduct. Yeah, unless it's really something like somebody killed somebody, that becomes murder, aggravated felony. As long as it's waivable, I don't think that's aggravated felony, because if it doesn't involve violence, yeah, that can be waived. Please. Okay, this person say, please, my question goes, can you file for your biological parents who were not married before you were born? What is the perfect thing to do? Yes, they are your parents. They don't have to be married for you to file for them. You're filing for them as their child. If you're a U.S. citizen child and you want to file for your parent, regardless whether they're married or not, you can file for them. You have to provide the birth certificate. Birth certificate showing their name on it, or you can do a DNA test to show that you are their child. You see? They don't have to be married for them to be your biological parent. You can prove it with DNA test. So that's pretty, not simple, but it's doable, basically. Let's see, who else has a question here? Yeah, so I'm still waiting for questions. If you have questions, please put it in the comment. By the way, you need to be liking this video. Please like. We only have 3 likes. On my phone, I can actually see, who's liking and who's not liking. I only have 3 likes. Please like. By the way, Unonji Ngwanda, please like. Thank you very much. You're welcome. Please like. because we only have 3 likes. We have 15 people in the house. Please like and please share, because we are sharing those news. So those who got their case dismissed, are they to receive green card? No. Child, you're so funny. No, you get the green card based on something, right? In order to get the green card, you have to have some type of underlining basis for it. Sorry. Some type of underlining basis for it. For example, someone gets a green card because a family member, relative has petitioned for them. Spouse, parent, child, U.S. citizen. Child, for child has to be a U.S. citizen. For parent, can be lawful permanent resident or U.S. citizen. Spouse, it can be lawful permanent or U.S. citizen. Family member, or maybe they win asylum, they can apply for a green card, or T visa, U visa, or employment based. Each category with its own requirements. So you have to have a basis for it, an underlying petition that gives you the eligibility for the green card. It's not because they dismiss your case. Charlie, so funny. Oh my God, somebody's coming with those. What is the third amendment? Can you imagine? I'm talking about immigration and this person is coming with third amendment. Oh Lord. Oh Lord, you need to Google it, because right now I don't know all the amendment in my head. You're so funny. I'm gonna have to check and explain to you what it is. Let's talk immigration. Okay. So anybody else has a question? Yeah, if you have a question about what's going on in Georgia, Texas, Florida, Tennessee, please refer back to my other video so you will learn what's really going on, what exactly can you do to protect yourself, especially in Florida, really. Yeah, it's really bad over there. Yeah, we have 5 likes. Please, we have 18 people in the house. Come on. We can get to 18 likes. Please like this video. Bye. Bye-bye, the silverback 20. Bye-bye. Please like, by the way. Yeah, I'm still waiting for your questions. The good news, one of the good news is this, is that if a person is trying to reopen their case, okay? They're trying to reopen their old case. Sorry, this is the time to do it. Why? Because the Dolly memo is still available. And we have been successful reopening cases, either with immigration court or the Board of Immigration Appeal, based on prosecutorial discretion. This is the time to do it because it's really working. If a person has some type of I-130 approved, this is the time to do it. Pour me. A person has been waiting for 8 years for asylum interview. What do? You sue USCIS. That's it. You sue USCIS for unreasonable delay. That's it. If you live in Maryland or in the District of Columbia, we can do it, because right now we can do it here in Maryland, or depending on where you live, right? If you reside in Maryland, let's do it. If you reside in the District of Columbia, let's do it. It's better to do it in the district in which you live, or state in which you live, so that the federal court doesn't dismiss your case based on improper venue. So Yeah, the best thing to do pour qui pourme is to sue USCIS for unreasonable delay. Once you do it, then USCIS will be forced to call you for the interview. And when they call you for the interview, they will be forced to give you the result of the interview within a reasonable time. That's it. Try to reopen since. S-A-R. S-A. Let's answer Pulkman first. What happens after you sue? What happens after you sue USCIS? The court will give USCIS 60 days to respond. And usually within 2 weeks, they will respond because they don't really want to fight that. 8 years is too long. They will respond. They will call you for the interview. That's it. They call you for the interview, and depending on the merit of your case, then they can either grant you asylum or not. But the goal is for them to call you. That's the reason you're suing, not for them to grant you asylum. No, they're still gonna go through the interview to see the merits of the case. You got it? By the way, we have 18 people in the house. Please like Pulkupomi. And SA, please like. You tried to reopen since 2018, but ICE is not helping. Well, I thought your case was about, what do you mean? It was already at the BIA. That's what my understanding was. And you wanted BIA to reopen based on defective notice to appear or something around those lines. They already remanded your case back to something around those lines, if I'm mistaken. Thirteen people in the house. Please like, please share. Anybody else has a question? Yeah, if you have a question, please put it in the comment. Yeah, as I was saying, right, this is the time to do it. This is the time to actually file for a prosecutorial discretion to reopen an old case if you are eligible to adjust status. You gotta be eligible to adjust status in order to convince ICE, regardless of the Dolly memo or not. Because if you're not eligible to adjust status, they're not gonna entertain that type of case. Meaning what? Meaning having I-130 approved, I-140 approved, VAWA approved, U visa, T visa, something approved that gives you the right to, that make you prima facie eligible for adjustment of status. So that's what I'm trying to say. Yes, if you have questions, please put it in the comment. Come on, let's get it. It's Saturday. Let's get those question answers. Let's get those question answered because people will always call you for questions. Now I'm available for those questions. If anybody need a consultation, again, you can schedule it. Consultation link is in the description box. Let's get it, let's get it. Yeah, I think anybody else? Let's see. Oh, okay, we have questions. Okay. I'm having you living USA in April with advanced parole, TPS order with previous overstay, and problem at the border when I try to come back. Thank you. Okay, when it comes to TPS holder, right? Arthur Frankowski. I haven't seen anybody being denied entry when it comes to TPS holders. As far as I am concerned, as far as my clients are concerned, TPS holder with travel document, valid TPS, valid travel document, they're not really having problem coming back. Yeah, because the TPS gives you like a temporary legal status and you have a travel document. So basically, yeah, you come back unless you have criminal records, right? But overstay, not a problem. You come back. But criminal record, I'm not really sure. But as far as I'm concerned, I haven't seen anybody with TPS being denied entry. Valid TPS, valid travel document, I haven't seen that being denied entry. No, I haven't. I have not seen that. Okay. Oh, OPLA joined to dismiss and remained to BIA from 6th Circuit to BIA, but ICE field office opposed with a brief. Oh, I see. They opposed, but are they going? So now what are you waiting for the decision? For the judge to make a decision? Yeah, now if they oppose, now you're just waiting for the judge to make the decision. That's it. That's sad. Yeah, I feel you now. That's sad. You're welcome. Anybody else? Anybody else has a question? Let's just answer those questions. Yeah, now I feel you. That's really sad because if the difficult part is for ICE to join, but once ICE is joined, why OPLA is joining and why ICE is refusing? That's sad. Yeah, just wait for BIA to decide because at this point, really, there's nothing to do. Yeah. Anyway, so I guess this is it, right? We got all the questions answered, by the way. Let's just hope that you get a good decision for BIA. But you know, BIA takes too long to respond, but eventually they're gonna respond. So let's just hope you get a good decision from BIA. I guess we answer all questions. Yeah, I know, based on Ms. Chavez v. Garland. Yeah, I'm not sure why the ICE office is basically refusing, really. If the notice was defective, why would they refuse, really? Ngwanda, yeah, you can file for naturalization if you have been waiting already for 3 years. 3 years, you've been waiting for the 3 years, yes, you can file for naturalization. But just know that when it's time to adjudicate your naturalization, you still have to be married to the person, living together and going to the interview together in order for that naturalization to be granted. But the answer is yes, if you've been waiting for 3 years already. Lucky Singh, is it that law in Florida? Because if you give the number, really, I can't remember all those numbers, but is it the one in Florida? Oh, brief were filed in June 2023. Yeah, lately I've seen like cases being like 13 months, maybe you might get a response. They're doing their best, right? At least to respond. Maybe by June of this year, you should get some type of response. Sorry. Lucky Singh, is it about those laws in Florida? DUI Act in Florida? Is it the one in Florida? Oh, yeah. They passed in the House. Which state? Which state has passed that one? Because there's a lot of things going on with different states. Really, I can't keep up. Which state? Is it Florida? I sent to the Senate to deport who have DUI. Yeah, but what I think is, I don't think it's gonna pass, because in order for DUI to be, it has to be aggravated, right? Oh, for the all US, oh, I haven't followed up with that one yet, but I don't think it's gonna pass. Like you think, I don't think it's going to pass. The reason I don't think it's going to pass is because DUI on its own cannot warrant deportation. It can trigger deportation, but the person cannot just be deported solely because of DUI. It has to be an aggravated felony. Like, let's say the person has DUI, then they went ahead, because of DUI, they kill somebody in the accident, then it becomes aggravated felony, then that person eventually will get deported. But just on its own, I don't think it's, yeah, I don't think it's gonna pass the Senate. That's what I'm saying. It might pass the House, but I don't think it's gonna pass the Senate. I don't think so. Yeah, that, you ask me what I think, I don't think so. I don't think so. Yeah, I don't think so. Yeah, because I have I have people with DUI that got green card before. So DUI can become worse if it's aggravated. If it's the first time, you can get a pass, but when it becomes aggravated, then, you know, it triggers deportation and eventually the person gets deported. But just because somebody got a DUI, they should be deported. I don't think it's going now. I don't think so. No. They're coming with a lot of things in a lot of states, but people are fighting back too, you know. Like the one in Texas, it has been suspended, at least for now, because at least people fought back, you see. So anyway, we have 20 people in the house. Come on, people, let's get those likes, and share. Anybody else has a question before we stop? By the way, if somebody is applying for adjustment of status under VAWA, it's better to wait for after April 1st, because adjustment of status filed concurrently with VAWA, those humanitarian type of visas, the price will be it's going to be waived. So basically it's going to be free. And yeah, but for other people, this is the time. Today is March 23rd. Yeah, you can still do it. 7 days is there. You can still do it at least Monday and Tuesday. Time to send it overnight, something around those lines, so you can have the price, because the price is going to be up to $3,000 for adjustment of status under marriage. With those other petitions like work permits, travel document. Okay. Please, how long is the consular processing case since? Oh, on average, Pella, on average, what I've seen, I don't know about Cameroon exactly, but what I've seen for cases really in general, it's taking 18 months consular processing for most cases, 18 months. Yeah, that's what I've seen so far. But I don't know for Cameroon specifically, because when I'm talking 18 months, I'm talking about Nigeria, I'm talking about Haiti, talking about Congo. Yeah, at least 18 months. Oh, like you see. Yeah, don't worry about it, because you already a green card holder. They're not gonna go and back and look for those. Maybe it's gonna be for people who are applying now, even if let's say the law passes and the bill passes and becomes law, it's gonna be for new people. They're not gonna apply it in retro. You know, they're not gonna go back to people already have their green card. That's not how the law works. So it's gonna be from this point moving forward. So retroactively, no, it's not gonna be applied like that. Yeah, you have to wait because of good moral and character. You have to wait. Yeah. Yeah, because if you apply now within that 5 years of statutory time, it's just gonna be denied for lacking good moral and character. Yeah, just wait an additional 5 years. Yes, that is correct. Some people, they just try and then try to waive, but you know, it's better to wait so you don't trigger a lot of things. In order to QT the wolf, this is my subject really. In order to adjust status, you're gonna have to reopen that case. Even if it was order removed in absentia, you're still gonna have to reopen it, dismiss it. Then you can adjust status with USCIS. I mean, in your case, we're gonna have to find out first of all why you didn't show up to court. If good cause is there, much easier to convince ICE to reopen it. Even if there's no good cause, we still can reopen it in terms of prosecutorial discretion. Then you can adjust with USCIS. QT the wolf, you need, yeah, you should schedule a consultation because really, this is what I do best. Schedule a consultation link is in the description box. Let's help you out. You're welcome. You're welcome, Pela. You're welcome, Lucky Sink. Yeah, Cutie, you're welcome. Really, the short answer is what I told you, right? You can adjust status, of course, but you're gonna have to reopen the old case, dismiss removal. That way you can apply with USCIS. Yeah, so, but you know, if you need guidance for it, you can schedule a consultation by using the consultation link in the description box. This is really the subject that I do best. Like, this is my area of expertise, reopening those old cases. Lucky, where am I located? Washington, D.C. Washington, like the D.C. area, metropolitan area, Washington, D.C., Maryland, Virginia, that's my area. I like those cases right there. But if we're gonna file with USCIS or we're gonna file a motion to reopen, I can file it from anywhere. I can take a case from anywhere. But as far as my specific location is Washington, D.C. Thank you very much. I guess we got everybody's questions answered. Thank you very much for showing up this lovely Saturday. Some people are like somewhere, but we are here to talk about immigration, answering your questions. Please like, please share. Follow me on all platforms. Sometimes I have good slides on Instagram explaining a lot of things. All the links are in the description box below. Until next time, bye-bye.